Did he try to make a traffic stop?
He literally detained me. Yes.
Okay.
He detained me. He would not let me leave.
Okay, but he's acting as a security guard here, right?
He didn't tell me that he was doing security here at all. He didn't say anything to me, and I have it all on film. I mean, we can review the footage.
My question is, what do you want me to do?
Well, first off, he detained me illegally, so let's start there. And then secondly, he's got police in the back of his squad car.
Okay, we established, though, that that's part of the car.
Okay, well, he still can't legally detain me.
Okay, how did he legally detain you? I don't know the details on that.
So, when you pulled up, where was his vehicle?
By your vehicle.
Was it by my vehicle or blocking my vehicle from leaving?
Blocking your vehicle.
Okay.
Okay. What happened after that?
He wouldn't move and he wouldn't talk to me.
Okay.
And I told him to move his vehicle, and I have it all on tape.
Say he's a police officer?
He did.
How did he say that?
With his mouth.
Well, I know, but what did he say?
Like over here, he said, I'm a police officer. And then I walked back over here to get my other camera.
Okay.
And then he pulled up and blocked my vehicle.
Okay.
And would not let me leave. That's illegal. And by the way,
Did he say why he detained you?
No, he wouldn't even tell me anything. He just held me captive.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, etc. And one of the things I also do is I do a lot of consulting for various organizations, whether that be other police departments, nonprofit organizations such as religious organizations. I do consulting for security companies, etc. And one of the things that always kind of comes up, and one of the things I get asked a lot, especially also in my firearm self-defense courses, is the Citizen's Arrest Doctrine, right? Citizen's Arrest, people that are not uniform patrol, people that are not sworn law enforcement officers, making detainments or making an arrest. And here we have a perfect example of this, right? We have somebody who is security. They may have law enforcement on their vehicle. I'm not really sure. That part of it, you know, goes without saying. Impersonating a police officer is a crime. But when it comes to when somebody is allowed to make an arrest or when somebody is allowed to detain somebody, especially when they're not law enforcement, what kind of issues arise and what are things that we need to be cognizant of? So again, let me just say that this is going to be a informational only video. The purpose of this is just to talk about the case law that's out there and just talk about the various doctrine as it's written and as we can perceive it from certifiable Supreme Court and Circuit Court case precedences. So let's just keep that in mind. But to start, let's kind of just rehash what we have in this video. You have what appears to be a law-abiding citizen that is recording, and he is stopped by a security guard. And by stopped, the security guard completely prohibits his ability to leave in his vehicle. And law enforcement shows up. Now the thing I find interesting, and again, I am a federally recognized law enforcement instructor, FLETC certified instructor, CLEAT certified instructor. I hold police certifications in various states, and I can tell you emphatically, without equivocation, there's just, from what I'm looking at, it just seems laziness on the law enforcement officer's part here. Some police officers are just scared of paperwork. I mean, that's just what it comes down to. They're scared of it, or they're lazy and they don't like it, or a combination of both, or they just don't know how to do it, right? And so here we have the officer saying, "Well, what do you want us to do about it?" Well, if somebody is telling you that they were unlawfully detained, that it's something that you should at least look into, right? It's something that we should at least look into and understand. And what I'm about to show you is a lot of people don't actually know the case law precedents. A lot of people don't actually know the doctrine when it comes to detainment and seizures. And it's really sad, and it's in my opinion, it's reckless and crazy. But we're going to go through a lot of case law here, so feel free at any time to not believe your lying eyes, right? I'm not here to trick anybody up, but we're going to go through a lot of it. So if you need to pause the video and just fact check what I'm saying, by all means. You know, it's important that you understand this knowledge. Better it is than it's more important that you learn it than just taking this information, at blind value, right? So let's start with the beginning. I think that one of the case laws that you guys see me use and talk about regularly is the stop and detain case law, right? We know Brown v. Texas. We talk about Brown v. Texas a lot. As you can see here on your screen, the Supreme Court has affirmed that law enforcement needs reasonable or articulable suspicion of a crime in order to detain and compel somebody to identify themselves. Again, Brown v. Texas, 1979. And so that's something that we need to understand. And the reason why that's important, and there's a reason why we need to understand that, is because that is the threshold. And this is the threshold for law enforcement. This is the threshold for anybody that's wanting to make a lawful arrest in order for law enforcement to detain and compel somebody to identify themselves. Again, Brown v. Texas, 1979. Now, here's the real interesting thing, because we're going to talk about it here in a second. But in statute, depending on what state you're in, we're going to talk about Oklahoma, just for precedence sake, but citizens in many places can make lawful arrests. So with that being said, if there's going to be a standard that you hold, the standard that you hold should be in compliance with Supreme Court case precedents. I say that, and I make the face that I make because it should go without saying, but law enforcement doesn't know this stuff, so I really can't expect the average everyday citizen to understand it. So again, that's what it is. The next thing we need to talk about is what is a seizure. Again, Supreme Court case precedents here. Torres v. Madrid, 2021. The Supreme Court holds that the application of physical force to the body of a person with the intent to restrain is a seizure if that person does not submit and is not subdued. Right? So the physical application of force to the body of a person with the intent to restrain or seize. I would argue that if I'm trying to leave in my vehicle and you block me in, that is absolutely a seizure. In fact, if we look at Brennan v. California, right, a traffic stop is considered a seizure. So again, we have all the elements and parameters required by the United States Supreme Court to very quickly in this video articulate that a seizure has occurred. So, if I was explaining it to a police officer, I could easily say, well, I absolutely was seized. Well, how do you know you were seized? Well, if we look at the applicable case law and doctrine on this officer, we have Brown v. Texas, 1979, Torres v. Madrid, 2021. I can go on and on, but a seizure did in fact occur here. So how about we do our jobs? The next thing that I think it's important that we talk about, right, is what is an arrest? Okay, so now let's look at another piece of case law that we find from the Fifth Circuit in 1988. Border Patrol agents seized a passenger suitcase and prevented it from being loaded onto a passenger airline flight. This constituted a full-scale arrest and was not just a detention because the passenger's itinerary was clearly frustrated. The officer failed to use the most diligent, least intrusive investigatory techniques. Again, the United States v. Cagle, 1988. So if we can articulate that by an agent of the state, by somebody, let's just take somebody, by somebody preventing you from leaving with your extra pair of jeans and toothbrush is considered to be a full-scale arrest, then blocking you in physically with their vehicle, I think is an easy articulation of a full-scale arrest based upon your itinerary being frustrated. If you're being blocked in by another vehicle intentionally, I think any attorney worth their salt would be able to articulate that was a full-scale arrest, not just a detention, but a full-scale arrest. Again, I didn't make this case law. This is not my case law. This is case law that was established in 1988. A lot of people don't realize this, and so this is something, again, when I do consulting for example, places of worship, churches, this is something that I always am sure to make them aware of, that just because you think you're doing something good and you are trying to get them to stay for law enforcement, right? You're trying to hold somebody there for law enforcement. Just realize that by, aggravating their itinerary, by clearly frustrating it, you have in fact conducted a full-scale arrest. So if you have conducted a full-scale arrest, make sure the elements and requirements have been met. Okay, so that brings us to our next. So here in the state of Oklahoma, we have arrest power for citizens. A private person may arrest another for a public offense committed or attempted in their presence, when a person arrested has committed a felony, although not in the person's presence when a felony has been in fact committed, and has a reasonable cause to believe the person arrested has committed it. Again, that's 22 Oklahoma Statute 22 Tech 202. Again, really goes without saying. And then let's just look very quickly. United States Department of Justice. What is an arrest? An arrest is defined as the taking, seizing, or detaining of another by any act that indicates intention to take person to custody and subjects him or her to the control of the person making the arrest. Again, this falls in line with every piece of nomenclature and case law precedents that we have already established therein. Again, it's really cut and dry. It's really cut and dry. So let's say, based upon what we have in this video, again, there's probably more to the video than we're not seeing, but again, that's not the purpose of this video. The purpose of the video is just to show us exactly where we're at and what we're doing here. So taking it at face value, right? If the security guard did not have reasonable articulable suspicion to make an detention, that means that they definitely did not have probable cause for an arrest. If they did in fact block somebody's vehicle in and refuse to let them leave, again, I'm going to let the lawyers hash that out, but I feel very confident based upon the case law, Supreme Court case precedences, and the circuit precedences that we have precedents for an arrest has occurred. Again, I'm pretty sure your $500 an hour attorney can easily make that case. So the question is, well, what happens next, right? Well, let's look at some more Supreme Court case precedents, right? Thompson versus Clark, 2022, fairly recent one. United Supreme Court have affirmed that a plaintiff suing for malicious prosecution does not have to be affirmatively exonerated of committing the alleged crime. Supreme Court's opinion, authored by Justice Brett Kavanaugh, held that no such requirement exists and that the plaintiff suing for malicious prosecution in the context of the Fourth Amendment claim need only show that his prosecution ended without a conviction. This Supreme Court case precedent sustains a victory for civil rights lawsuits. So what does that mean? It means that exactly what it says. If you were to be arrested, right, if this person were to be arrested, which it clearly shows that an arrest has occurred, he doesn't have to be exonerated in a court of law, right? He doesn't have to. And in fact, it looks like he was arrested, and when the cops showed up, it went away, right? Not that could actually happen in real life, but it went away. So what this essentially means is, right, even if this person had been arrested and had been taken to jail and had been charged, that doesn't mean that they can't sue civilly. They don't have to be affirmatively exonerated. Just because the charges are dropped doesn't mean that they can't go after them civilly. So in this case, it just shows even further that nothing actually happened. Somebody did make an arrest, right? Based upon the articulation what we have, I think it's very easy to see that an arrest had occurred here. And according to the Supreme Court, it doesn't have to be exonerated for the person to go after them civilly, and that is for law enforcement. So for somebody who's not law enforcement, again, they don't have those qualified immunity protections. You're putting yourself. What I'm trying to say is you're putting yourself in extremely litigious waters here. Okay. So what happens if a seizure is found unconstitutional? Again, let's look at Anderson versus Creighton, 1987. The Supreme Court held that an officer who conducts a search that violates the Fourth Amendment is entitled to qualified immunity if the officer proves that a reasonable officer would have believed that the search constitutionally complied with the Fourth Amendment. The relevant question the courts must ask is whether a reasonable officer could have believed the warrantless search to be lawful, considering established case law and information which the officer possessed. The Supreme Court also held that the subjective beliefs about the search are irrelevant. So again, this goes to a search. Obviously, if you're arrested, you're going to be searched incident to arrest before you're taken to the jail, etc., etc. And so here, it basically says that, in order for an officer to be granted qualified immunity, they would have had to have reason to believe. In this case, since they're not law enforcement and we don't believe this person is law enforcement, that wouldn't even apply. So it puts that person in more litigious waters. Okay, here we have what happens if an arrest is found unconstitutionally. Malley versus Briggs, 1986. A police officer may be sued civilly for monetary damages by the victim of unlawful arrest. Okay, plain and simple, they can be sued. So if a police officer can be sued, somebody who is not a police officer that does not have qualified immunity can also be absolutely sued. Something also think about Pearson versus Callahan, 2009, also when it comes to qualified immunity. But again, that's not necessary in this particular case for the simple fact that, this person is not known to be law enforcement. Now, let's talk about why this matters in other terms, right? So what happens if somebody does this? Well, a lot of people are saying, well, is that kidnapping? Well, let's just look at it. Just look at it. So, 21 Oklahoma Statute 741, right? This happened in the state of Oklahoma. Any person who, without lawful authority, seizes, confines, inveigles, decoys, kidnaps, abducts, or carries another away with intent either to cause such person to be confined or imprisoned in this state against the will of the other person, or to cause such other person to be sent out of the state against his or her will of another person, or to cause such person to be held as a slave in any way in service against the will of the person. So I think number one has been absolutely met, right? I think that somebody could easily argue that the purpose of the security guard blocking their vehicle in was to hold the person in confinement or imprisonment. I think that's evidently what an arrest is, right? So you have that. But let's flush this out, because while we have the statute, maybe it's overly vague. Let's make sure it's not overly vague. So the next thing that I would go to is the Oklahoma jury instructions. So that would be OUJI, TAC CR, TAC 4, TAC 110. Kidnapping elements. So no person may be convicted of kidnapping unless the state has proved beyond a reasonable doubt each element of the crime are present. So one, unlawfully, right? So if you don't have probable cause, you can't make an arrest. If you don't have reasonable articulable suspicion of a crime, you can't detain. So in this case, if that wasn't there and it doesn't look like it was there, that would be unlawfully. So, unlawfully, element one, met. Second, seizes, confines, decoys, kidnaps, abducts, carry away. I think that we made it very clear that a seizure did occur, right? Torres v. Madrid, 2021. So I think the elements that have been set forth by the Supreme Court case precedents of seizing and confining, 100% there. I don't see how somebody could argue. That. Third, another person. Well, we do have a victim, right? We do have a person who's a victim here who's claiming victimhood. So, boom, you got number three. Number three is there. And fourth, with the intent to confine that person or imprison that person. Well, if you're making an arrest, what are you doing? With the intent to confine and imprison. So let's think about this for police officers for a second. When you make an arrest, are you seizing and confining them? Yes, you are. So let's just take number one out. So if you're a police officer, are you seizing somebody? Yes, you're putting handcuffs on them, you're seizing them. Third, are you doing it to a person? Well, yes, you're going to put that person on your affidavit. Fourth, with the intent to confine. Yes, you're intending to take them to jail. So what's the only difference here? Number one, the unlawfully part. So if you are a police officer and you're doing a detention with reasonable articulable suspicion, as pursuant to Brown v. Texas, 1979, then yes, you're doing it lawfully. So therefore, kidnapping would not apply. But if you were to do this unlawfully, you would meet all the elements for kidnapping. But let's say you don't believe me, right? Let's say, hey man, I see the evidence you're putting out. I'm just not 100% in fact sold. I get it. Let's look at the notes on use, right? Pursuant to in accordance with court case precedents, right? Again, the statutory language reads without lawful authority, but the original jury instruction commission has translated this language into the word unlawful in the first element. The commission has decided that the words without lawful authority and unlawful are synonymous. So the commission is choosing to use the words unlawful in order to promote consistency of language among various instructions. Moreover, the word unlawful is more precise. The definition of the word unlawful should encompass either two concepts. Number one, the person who confines another lacks legal or domestic authority, or the person who confines the other has used fraud to induce consent to the confinement. Either lack of authority or use of fraud makes the confinement unlawful, pursuant to in accordance with Williams v. State. It's all right there, man. So again, even if you didn't like how I presented that, if you look at the notes on use for this jury instruction, it says it perfectly right there, right? So again, it is what it is. This is the truth of the matter. This is where we find ourselves. So again, I say all this and I present all this case law and I present this in a factual way because for those of you that are law enforcement, again, especially in the state of Oklahoma, it's a fine line, right? If you do something unlawfully, you are kidnapping. Again, it's straight. That's coming straight from statute, from the circuit court and the Supreme Court. It's there. Again, don't believe your lying eyes. Look these cases up for yourself. Number two, if you are a law-abiding citizen or you're just an everyday citizen, I'm not saying not to make citizens arrests, right? I'm not going to tell people what to do. But if you're going to do that, you're putting yourself in a litigious spot, especially if you don't understand the proper application of doctrine. Again, plain and simple. This stuff is plain and simple. It's written there, in my opinion, in pretty plain English there. So there you have it. If you guys thought this video was helpful, please like, share, subscribe. But most importantly, tell me what you think. I'm very curious to know what you think in the comment section below. What do you think of this case law? What do you think I got right? Do you think anything I got wrong? What is your advice to people that want to jump in and intervene? Let me know in the comment section below. And as always, guys, long live the Republic.